Good afternoon, everyone. I'm glad to see so many people already on this call for our webinar. Today, our topic is spousal support and family property. So I'd like to welcome you all to CCMW's Spousal Support and Family Property webinar. We still have a few people logging in, so we're going to give them a minute or two to get settled, and then we'll get underway. Let's just hold on for a few minutes. In the meantime, we should just check in to see if everyone can hear us. And we do have Sabrina on standby for any kind of technical troubleshooting. Hopefully it'll all go well. But just let us know if you're having difficulty through the chat, and we'll give you a phone number as well if you continue to experience any technical difficulties. I think we can get started now. So, once again, welcome to CCMW's Spousal Support and Family Property webinar. I'd like to now proceed to some housekeeping notes. Thank you for taking the time to join us today. My name is Mrs. Jaffrey. I'm the Executive Director of the Canadian Council of Muslim Women, and I will be your moderator at the beginning. And then, of course, Sabrina Zrek, our projects coordinator, will take over at the end. Before we begin the webinar, let's go through some housekeeping rules. Today's webinar is being recorded. The recording of this webinar will be available afterwards on our website at www.ccmw.com. We welcome you to revisit the content yourself and share it with your networks. Please ensure your video camera and microphone are muted during the webinar. This will help eliminate ambient noise and increase clarity. We invite your comments and questions, and we'll run a live Q&A session at the end of the webinar using the chat box. The chat box button is the sixth button from the left at the bottom of your screen. Once you click it, the chat box will appear on the right-hand side of your screen. If you think of a question at any point, just type it in the chat box, and Sabrine will pose it during the Q&A portion. You could choose to ask the question anonymously by sending the message to Sabrine, she's the host, as opposed to everyone. An evaluation will be emailed to you later today. It'll take about 5 minutes to complete. Please don't include your name on this form in order to maintain your anonymity. The information you provide will be kept confidential and private. Only authorized individuals at CCMW will have access. If you require technical support, please send Sabrine a direct message using the chat box or text her at 416-897-1907. I will repeat, please use the chat box or text Sabrine at 416-897-1907. So I'm going to now walk you through our mission and vision statements. The Canadian Council of Muslim Women, or CCMW, is a national nonprofit organization committed to attaining equality, equity, and empowerment of all Muslim women in Canada. Founded in 1982, the organization works to promote Muslim women's identity in the Canadian context. For more than 37 years, CCMW has proudly advocated on behalf of Muslim women and their families and developed national projects that enrich the identity of Canadian Muslims, encourage civic engagement, and empower our communities. During the past several years, the Canadian Council of Muslim Women has undertaken initiatives to inform Muslim women, the legal profession, community service agencies, policymakers, and the general public about the differences between Muslim family laws and Canadian family laws. Previously, CCMW published Muslim and Canadian Family Laws, a comparative primer in English and French, and a series of booklets in several languages on family law topics to further its public education efforts. Our latest project in this field, Muslim Women's Family Law and Legal Rights, is updating these documents and disseminating them via knowledge sharing workshops within different cities across Canada for Muslim women, community service providers, the legal profession, and the general public. In 2003, CCMW took the lead in establishing a coalition against religious arbitration in family law, composed of over 50 sister organizations, including the National Association of Women in the Law, that's NAL, MATRAC, and the YWCA. The No Religious Arbitration Movement and CCMW's work represented an array of complex issues and events. We were successful in that the Government of Ontario made a decision to disallow the use of religious family laws under the province's arbitration. CCMW was compelled to inform Muslim women about the choices they have available to them within Muslim and Canadian family laws, and simultaneously educate individuals and institutions that assist them or work with them to resolve family disputes. CCMW is composed of a national board that works to further CCMW's objectives at a national level, and 15 local chapters made up of members whose passion and hard work advance the vision of CCMW within local communities. To learn more about CCMW, visit http://www.ccmw.com. I'm now going to turn it over to Pamela Cross, who will be our facilitator for today's webinar. Over to you, Pam.
Thank you very much, Nizet. And let me also say hello and welcome to all of you who are taking time out of your, no doubt, very busy days to join us for this webinar, which is produced by the Canadian Council of Muslim Women. As Nizet said when introducing me, my name's Pamela Cross. I'm a lawyer. I work with a broad range of women's equality and violence against women organizations across the country, including CCMW, where I've been involved in a number of projects over the past several years. The focus of all of my work with CCMW, as well as with other organizations, is on violence against women and the law. Today, and for the upcoming webinars, we're also being joined by Professor Omar Farahat, who was involved in the earlier stages of this project in developing the Muslim law content. And I'm going to, in just a second, ask him to say hello to all of you, but just so you understand his role with us this week and in the upcoming weeks, he will jump in as he sees fit throughout the presentation to add to anything that I'm saying or to correct anything that I get wrong. But primarily, he's here to answer any questions you have about Muslim law and how it affects particularly Muslim women who are living in Canada. But Omar, do you want to just say hello to everybody?
Hello, everyone, and thank you very much, Pam, for the introduction, and happy to be here. Looking forward to the discussion.
That's great. We're really happy that you're able to be with us as well. I'm honored to be facilitating this series of 7 webinars, which reflect the content in 6 brochures produced by CCMW that provide comparative information about Canadian and Muslim family law, particularly as those laws pertain to women's rights. The topics covered in the brochures are marriage, divorce, custody and child support, family property and spousal support, which is what we're talking about today, domestic contracts, and inheritance. The goal of the written materials, as well as these webinars, is to assist Canadian Muslim women in being able to make informed choices in the area of family law in Canada. We hope the resources will also be of assistance to professionals who work with Muslim women in the family court system, students who would like to know more about these issues, and community-based services that assist women. Here you can see the covers of all of the brochures, all of which are available on the CCMW website. The content of both the brochures and these webinars is based on Muslim and Canadian family laws, a comparative primer, which was published by CCMW in 2006 and updated by CCMW last year. Please note that the information contained in these webinars is just that. It's information. It's not legal advice. It should not be interpreted as legal advice. So even if something that I say or something that Omar says sounds like it applies directly to your situation or the situation of a colleague, a client, a family member, it may or it may not. It's information. It's not legal advice. If you or someone you know is dealing with a family law issue, it's very important for them to meet with a lawyer, to share all of the facts of their situation, and then to receive legal advice. The webinars, the brochures, and even the primer are not a replacement for legal advice. Just a reminder to all participants to please mute yourself so that I think we've got another conversation going on here. Can that person please mute?
The grandkids.
I can't really talk over another voice. Muted? Okay. If you want to find out about the sources and validity of Muslim laws and legal opinions referred to in these webinars, we suggest that you consult Muslim and Canadian Family Laws, a comparative primer. Laws in a public legal system are in a constant state of flux. They change to adapt to the times. What you hear today, what you hear in any of these webinars, and what you read in the brochures is accurate to the date the webinar was recorded, and in the case of the brochures, the date they were published. And that information is visible in all of the resources that we're posting online. We encourage you to verify that any of that information is still current at the time you read it or hear it. At the end of the presentation, as Nuzet has already referred to, we'll have time for questions and answers. Please pose your questions by writing them into the chat area on your computer screen. Then the questions will be read out so everyone can hear them, and Omar and I will do our best to answer them. We are also providing or preparing an FAQ resource so that any questions we don't get to in the question period, we will answer after the webinar, and then those questions and answers will be posted on the CCMW website. And we do encourage you to enter your questions as you think of them, rather than hoping that you'll remember them until it's time for the discussion. Let's move into the topic for today's presentation, which is spousal support and property division. Traditional Muslim law does not recognize joint property or joint finances for married people. Each spouse retains their own separate patrimony, which means property they've inherited, before, during, and after marriage. The family home, which is provided by the husband, remains his property, unless it belonged to the wife prior to the marriage, or was explicitly gifted to her by her husband, thus leading to a transfer of ownership. Financial support of the wife and children is the husband's obligation. It's the primary obligation that follows from the marriage contract by force of law, without the need for any specific provision about this in the contract. In other words, it's assumed. It doesn't have to be set out explicitly. Classical scholars have long debated the circumstances under which such an obligation may be suspended, but in general, such conditions remain very limited and are rare exceptions to the general rule. In Canadian law, marriage is seen as a partnership, with each person making roughly equal, even if substantially different, contributions. For example, if one spouse works outside the home and the other works at home, raising the children and running the household, perhaps also supporting the other spouse's employment, promotions at work, and so on, These two contributions are deemed to be equal under Canadian family law. Each spouse is to benefit equally from those two sets of contributions in terms of distribution of property if the marriage comes to an end. And we'll get into the more details about how that happens in a few minutes. This principle underlies Canadian family laws with respect to the division of property, which are dealt with primarily under provincial or territorial laws. In Ontario, it's the Family Law Act that sets out how property is to be divided. But the general approach is similar in almost all provinces and territories. Quebec is a bit of an exception. It has quite a different property regime when it comes to common law couples in particular. Because the marriage is viewed as a partnership, both people have a legal right to an equal share of the property that was accumulated during the marriage, whether or not they contributed financially to it and whether or not their name appears on the ownership papers, whether that's a deed to a house, ownership papers for a car, the name on a bank account, and so on. In other words, even if one spouse has not contributed money to the purchase of RRSPs or a car, they still have a right to an equal share of the value of any of that property that was acquired during the years of the marriage. That applies to debt as well. And often when we talk about property division, we only think about the assets. We think about things that we have that we still want to keep or that we don't want to share with our spouse. But that concept of equal partnership and sharing also applies to debt. There are some very minor exceptions to that, but generally speaking, if you're married and your spouse has a credit card, you share in the debt that's on that credit card, whether or not you were aware of the expenses that your spouse was putting onto that credit card. For those who are married and who want to use a different regime, in other words, what's yours is yours and what's mine is mine, more like the Muslim approach to property, those people can deal with property by way of writing a domestic contract, a marriage contract, or say a cohabitation agreement. And we're going to talk about those in detail in next week's webinar. So that's a little bit about how the property works for people who are married. Spousal support is the money paid by one spouse to the other for that person's support after the marriage has ended. For the purpose of spousal support, spouses are defined as people who are married to each other, but also people who, while not married, have lived together continuously for at least 3 years, or who have a child, either born to them or adopted by them together. So even if you're not married to your partner, if you've lived together for 3 years or you have a child together, you're considered a spouse for the purpose of spousal support. We talked about child support last week, so those of you who were with us then will know that in each province and territory, there's an enforcement agency to ensure that child support payments are made and are paid to the person who's supposed to receive them. The same is true for spousal support payments. But if there is a conflict, in other words, if there's a child support order and a spousal support order, and the person paying those supports can't afford to pay both of them, child support gets favor over spousal support. And if that's confusing, please feel free to put a question in the chat area and we can talk about it in the discussion period. Because marriage is seen as a partnership under Canadian law, there's no legal provision that requires one spouse to support the other while they're married. It's assumed that both spouses will ensure the financial needs of the other are taken care of while the relationship is intact. And married couples do this very, very differently, as do common law couples. In some marriages or in some common law relationships, the couple has a joint bank account. Each person puts in enough money to cover their common expenses, let's say the mortgage, the utility bills, the groceries. Sometimes they each put in an equal amount of money. Sometimes they put in money proportionate to their income. So if one person is earning twice what the other is earning, they put in twice as much. And then each person's free to do what they wish with the remainder of their income. In other relationships, one person takes on paying certain expenses, the other takes on paying other expenses. It's certainly where one spouse is not working for money, So typically that would be the spouse who's at home raising the children. Typically in those relationships, the spouse who's earning the money is paying all of the bills. But none of that is set out in law. That's something that it's assumed people work out between themselves while they're cohabiting, while they're married to one another. Under classical Muslim law, marriage does not result, does not result in any joining of property or financial means. This is because marriage was not seen traditionally as a union between financial equals. Under classical doctrine, the man was the sole and absolute provider for the family because at the time, the man was the one who was earning the income. Marriage was seen as an arrangement in which the woman would relocate from her father's to her husband's home in exchange for a dower, which we discussed in the webinar on marriage, and full financial support. Thus, the man's house, along with everything he acquired for it, remains his, even if that property and the possessions within it were used jointly by the spouses. While this arrangement deprives the woman of any rights in property acquired for the family by her husband, she gains by retaining full rights to her own money and property, including her dowry, any gifts from her husband or her family, her inheritance, and any returns on investment, rent, or other income. Just as she doesn't have a right to the property of her husband, the husband has no right to any portion of her wealth under the principle of division of legal patrimony. The issue of separate ownership of family property is often addressed in Muslim law through the inclusion of carefully drawn conditions in modern marriage contracts. For example, in some cases, the bride will require the transfer of the family home to her ownership as part of the dower, or the future modification of dower to account for inflation. Perhaps during the discussion period, somebody from CCMW might like to talk a little bit about CCMW's work to develop a Muslim marriage contract, because I think that's a really important document that can ensure Muslim women who marry are as well protected under both systems of law as possible. As I've already said, the basic principle underlying the division of family property in Canadian law is that marriage is a partnership. That means that all property accumulated during that partnership should be shared equally between the partners, the spouses, regardless of who actually paid for it. This is called in Canadian law equalization of net family property. There are certain exceptions to this principle. Property acquired before the marriage doesn't form part of net family property. Property that is acquired by gift or inheritance from a third party, proceeds of a life insurance policy, or any property that the spouses have specified ownership of in a domestic contract. In other words, at the time that I marry, I could write a contract, a marriage contract with my spouse to be that would stipulate, for instance, that a particular piece of property is mine and will remain mine, and my spouse to be agrees that he or she will never make a claim against that property. Perhaps most importantly to remember when we think about property under Canadian law for married people, the matrimonial home is treated differently than other property. So if you remember, what I've just said is that the couple, when they separate, equalize net family property. And that's the property that was accumulated during the marriage. Matrimonial home is different. The full value of the matrimonial home is to be shared equally between the spouses, even if the home was bought by one spouse prior to the marriage. For example, if I own my house fully, there's no mortgage on it, I've lived in it for 15 years, and then I marry, and my spouse moves into this home with me, this becomes our matrimonial home. If we separate some years later, I must share the full value of the home equally with my spouse, even though they've made no financial contribution to its value. If we compare that, say, to a pension, Let's say I've been accumulating a workplace pension for 10 years. I marry. 10 years later, my spouse and I separate. My spouse has a right to claim equalization of the amount that the pension increased between the date of marriage and the date our marriage ended, the date that we separated. I'm just using those two examples because they're the most common substantial property that couples own in Canada, but you could look at anything else the same way. I bring a car into the marriage. Well, cars are a bad example because they decrease in value over time. I bring some antiques into the marriage. They were worth $10,000 on the date of marriage. When we separate, their value has increased to $15,000. All that I have to share with my spouse is the $5,000 that the value of those antiques increased over the years we were married. So I hope that's worth $200,000. We split the difference so that he pays me $50,000 or gives me something worth $50,000. And now we're both equalized. We both have property worth $150,000. I hope that's clear. It's always difficult to explain how property division works. I like to do it with a chalkboard and a piece of chalk and add and subtract things in front of people. But as I say, I'm happy to come back to this in the discussion period. One important point to add here, and remember, we're still just talking about people who are married. Ontario legislation governs the division of property in some polygamous marriages, even though polygamy is illegal in Canada. A woman who was part of a polygamous marriage, if that marriage took place in a country where polygamy is legal and recognized, in other words, not in Canada, a woman in that situation can rely on Ontario law with respect to the division of family property when that marriage ends, if she is resident in Ontario. And I'm sure you're going to have questions about that for the discussion period as well. Under Muslim law, the wife does not have a legal claim over the matrimonial home, including its financial value, unless it belonged to her before the marriage, as we've touched on earlier. There are no formal rules about the division of property under Muslim law, but it is discussed, albeit without any consensus. Opinions vary from the woman getting all the household goods to getting only the clothes on her back, essentially getting just what she brought into the marriage. Under Canadian law, the matrimonial home is the place where the spouses ordinarily lived during their relationship. Only married people can have a matrimonial home. So if somebody is living with their partner, even if they live with that partner for 30 or 40 years, the home they live in is not called, in law, a matrimonial home. For married people, there can even be more than one matrimonial home. If, for instance, a married couple owns a house in the city, also has a cottage where the family regularly spends time, both are considered matrimonial homes for the purpose of property division. Both spouses have an equal right to live in the matrimonial home unless one received a family court order for exclusive possession of it. Possession in no way affects ownership or the right to include the matrimonial home in the calculation for the purposes of equalization. In other words, if the wife has an order for exclusive possession of the matrimonial home, that means that she and the children can live there and the husband cannot come onto the property. However, he continues to have a financial interest in the house. And at some point, if the house is sold or as the part of the terms of the divorce, he will be able to make a claim to half the value of that home. In other words, possession does not equate ownership. Let's talk about spousal support now. Under Muslim law, the husband owes his wife two main obligations: the dower, which we discussed in an earlier webinar, and maintenance, which under Canadian law is called spousal support. And that is due throughout the marriage. Classical scholars have disagreed on when the payment of maintenance to the wife is due. A majority have held that it's due from the moment the marriage begins until it ends. Some scholars have allowed for exceptions to that rule. This includes the case of a minor bride who continues to live in her father's home after the marriage has taken place. In that case, the husband may withhold payment of maintenance until she moves to his home. In general, the payment of maintenance was seen by most scholars as the husband's most fundamental obligation, and refusal to pay on his part had to be justified by a substantial neglect of marital obligations by the wife. Since living in the marital home is the wife's most basic obligation, just as payment of maintenance is the husband's most basic obligation, desertion by the wife of the husband was the main situation in which this payment, the payment of maintenance, could be justifiably suspended. There is a misconception that in Muslim family law, a wife must be obedient to deserve her financial support. This usually follows from a misunderstanding of the concept of disobedience as a lack of submission to the husband's wishes. That's far from the truth. What most classical jurists meant by disobedience was not that the wife was expected to unquestioningly submit to the husband's will, but rather disobedience was meant to reflect abandonment of the family home altogether. So this really goes back to the wife's most basic obligation to live in the marital home with the husband. No significant classical school has held that the husband may suspend maintenance if the wife simply does not fully submit to his will. In fact, it's a deeply held assumption in Muslim law that marital relations should be based on reciprocal understanding rather than the obedience of one spouse to the other. Therefore, all scholars agree that a wife is entitled to full support covering her livelihood, clothing, and in some cases, domestic help, as long as she continues to reside in the marital home. Some scholars have argued that a wife who abandons her home is still entitled to support, but that's a marginal opinion. In general, this maintenance is only paid while the marriage is still intact. Upon divorce, the obligation usually comes to an end. However, a pregnant woman will receive support until the baby is born and for some time following that. This has traditionally been taken to mean a period of 2 years, but many modern interpreters argue that this can be extended until the woman remarries. There's no consensus among Muslim schools of law on the amount of maintenance. Some jurists take the position that the amount cannot be specified by law, since it depends on many conditions, such as each spouse's background and circumstances, economic conditions, the place and time in which payments are due, among other matters. Others have argued that the amount of support can be calculated based on the husband's wealth and income. The higher the income, the higher the amount of support. There is a consensus, however, about the basic elements of such support. Besides the home, the husband is responsible for the wife's daily necessities, such as food and other ordinary needs, as well as clothing. While these are defined as necessities, that does not mean the husband's obligation is limited to the bare minimum. A wealthy man could potentially be required to provide a substantial level of maintenance. Beyond these necessities, food and other ordinary needs, there has been disagreement, with the majority believing that a woman who is not well versed in housework may require her husband to pay for domestic help, and a minority taking the position that there's no such obligation according to Muslim law. Under Canadian law, both the Federal Divorce Act and provincial territorial laws, in Ontario, the Family Law Act, set out objectives for spousal support. These objectives are to recognize the economic advantages or disadvantages arising from the relationship or its breakdown, equally divide between the parties any financial consequences arising from the care of children, relieve economic hardship arising from the breakdown of the relationship, and promote the economic self-sufficiency of each partner within a reasonable period of time. People in long-term conjugal relationships, even if they were not married, may qualify for or be required to pay spousal support if those above criteria are met. Whether spousal support is to be paid, how much it should be, and for how long it will be paid is very dependent on the circumstances of the relationship. Typically, in the case of a long-term traditional marriage where the woman has remained at home for all or most of the marriage to raise the children and maintain the household, spousal support will be ordered for a long period of time or even permanently at a high level, depending, of course, on the income of the husband. It's not uncommon for spousal support payments to be made until the recipient spouse remarries, and even in some circumstances beyond that time. In a short-term marriage in which neither party's ability to earn an income has been negatively affected, there may be no spousal support at all, even if one of the spouses earns significantly more money than the other. Where one spouse, typically the woman, who has left the workforce to raise young children, requires a period of time to reestablish herself in the workforce, there may be a short-term spousal support order for a gradually decreasing amount of support over time. When determining the amount of spousal support to be made, the courts will take a number of factors into consideration, including the length of the cohabitation and the functions performed by each spouse during that time, child rearing versus earning an income, for example. Any agreements that the parties have entered into, for example, a marriage or cohabitation agreement, the parties' current and likely future assets and means, the dependent partner's capacity to contribute to their own support, and the ages and physical and mental health of the parties. I think the easiest way to explain this properly is to give you a couple of different examples. And these are general. So, again, it's information, it's not advice. And they're very simplified scenarios that I'm going to share with you here. Example one, two people are married and they have been married for 50 years. During that period of time, the wife, as is still more common, has not been in the paid workforce. She left the paid workforce when their first child was born. The husband's career has been very successful. Over time, he's advanced, whatever his job is, he's advanced to a very high level. He has a significant income. And even though the children have long since left home, in fact, there's some grandchildren now, the wife has not returned to work. The husband finds it more convenient to have her at home, able to run the household, do business entertainment for him. In fact, his job requires him to travel a great deal, and he likes to have her company while he does that. So now they're separating, and she has no income. Not only that, she's been out of the paid workforce for a significant number of years. She is quite likely beyond the age of general retirement at this point. In that situation, the husband is going to be paying her support indefinitely, and it's going to be the support at a fairly high level because the court will feel, if they can't decide on this themselves, that she has a right to maintain a similar standard of living to the one that she had while they were together. And equally importantly, her inability to provide for herself financially is a result of the roles that the two of them agreed they would play during the years of marriage. If we go to the other end of the spectrum, two people get married, they're married for 7 years, neither of them leaves their job, they don't have any children. Even if one of them earns quite a bit more money than the other one, there isn't an automatic likelihood that spousal support would be paid because nothing in the marriage has changed the ability of either of them to support themselves. Finally, by way of an example, one that sort of sits somewhere in the middle, two people have been married for 15 years, they have two children. It was agreed that, and just because it reflects reality, I'll say once again, the wife will stay at home with the children. She hasn't gone back to work yet. The youngest child has just started kindergarten, so isn't in school full time. They separate. There will be spousal support paid by the husband to the wife for a period of time, but there may well be an expectation that the wife will be able to return to the workforce. She may need some time to get the youngest child into full-time school. Perhaps she needs some time to retrain or update, depending on what her work was before she left the workforce. And so the amount of support may decrease over time, and it may have an end date attached to it. So I hope those examples are a little bit helpful in understanding how spousal support works under Canadian law. I just want to stress again that spousal support is paid when people have been married or when they've lived in a common law relationship, if they've lived together for at least 3 years, or if they have a relationship of what is called reasonable permanence, and they are the parents together of a child. The federal government has established spousal support guidelines, somewhat like the child support guidelines, and those to some extent standardize the amount of spousal support that's awarded, although unlike the child support guidelines, which are actually the law, spousal support guidelines are guidelines. Usually, a spousal support agreement or order will specify that that support ends on the remarriage of the person who's receiving the spousal support, not on the remarriage of the person who's paying it. Unlike child support, spousal support is tax deductible for the person paying it, and the person who's receiving it must declare it as taxable income. As I mentioned earlier, spousal support orders are enforced using the same mechanism that's in place to enforce child support. In Ontario, that's the Family Responsibility Office. People in both married and common law relationships can use a domestic contract, which we'll be discussing in the next webinar, to set their own approach to spousal support, as well as other issues related to their relationship. I want to just briefly go back to the issue of property and the division of property before we open this up for any comments that Omar might like to make, and then for questions from any of you. When I talked initially about Canadian law and property division, I stressed the point that marriage is seen as a partnership with each person making roughly equal, even if substantially different, contributions to that partnership. Common law relationships, despite the fact that they've become much more common in the last couple of decades, are not viewed that way by Canadian family law. Two people who live together neither of those people has a statutory right to half the value of any of the property that's accumulated during the time that they're living together. If I move in with my partner and we don't marry, and we've moved into the house that my partner owned before, so the deed to the house is in my partner's name, that's his house and it remains his house. Likewise, if my partner moves into a house that I own and my name is the only name on the deed, then the same is true for me. That's my house and it stays my house. If we buy a house together and both of our names appear on the deed, then we share it equally. But that would be the same if I bought a house with my sister and both of our names went on the deed, then we would share it equally. If people who live together wish to share their property equally, at the end of the relationship, they need to write a domestic contract, a cohabitation agreement that sets that out. Even without a domestic contract, if at the end of a common law relationship, one spouse, let's say the woman, feels that she's made contributions to the other partner's property, she can go to court and bring a particular kind of argument, it's called a constructive trust argument, to say that she should have a share of the value of that property. So here's a fairly simplistic example. I move in with my partner, we don't marry, it's his house, his name is on the deed, he's paid the mortgage off long before I met him. But we decide to have a family together, and so we put an addition on the house, so we have extra bedrooms for the kids, a family room, and I pay for that addition. I can go to court and argue that his house is now worth considerably more than it was on the date that we began to live together because of the improvements we've made to the house. And if I can show the court that I paid for those improvements, then I can have a share in the increased value of the house. Unfortunately, the way a lot of families operate, the husband or the common law, the male common law partner covers the big expenses like the mortgage and so on. And the wife is paying for things like groceries, not keeping receipts. So even if the fact that she's been buying the groceries for 15 years has enabled the common law partner to make the mortgage payments on the house, she may have difficulty proving that in court because she doesn't have receipts to show. But there's all kinds of expenses that one partner can claim show that they should share in the value of the family property, even if that property is owned by the common law partner. Paying for vacations, paying for improvements to the home, staying home to raise the children in order to support the common law partner's career. All of those things may be admissible as evidence if that common law partner brings one of these constructive trust claims in family court. The important thing to remember is that there's nothing written down in law that says a common law partner is entitled to share in the value of the family property. So we've covered a lot of ground here this afternoon. We've looked at family property for married people under both Muslim law and Canadian law. We've touched briefly on family property for people who are in common law relationships under Canadian law. And we've looked at spousal support or maintenance under both Muslim and Canadian family law. I'm guessing there's probably a lot of questions. Omar, I don't know if you have any comments you want to make before we open things up to questions, but now's your chance, and then we'll have Sabrine.
No, thank you. Looking forward to the questions.
Great. So Sabrine, can you take us through the questions?
Yes, of course. Thank you, Pam, for that excellent presentation. So I'm going to get started straight to question 1. The first question is divorce still valid and complete if the ex-couple decides not to split the assets? He moved out and we are legally divorced, but both of us still want to remain on title of the matrimonial home. Is that legal?
If you're talking about under Canadian law, sure, that's legal. There is a time limitation in terms of dividing property, but if both people have their name on the deed, if they own the house as joint tenants, you can continue to do that for as long as you like. Now, there are some not complicating factors, but additional factors. So let's take this story and add some more details to it. These two people have divorced. Both of them own the house. Both of their names are on the deed. One of them has continued to live in the house and is making the mortgage payments on that house. Then at some point in the future, when the house sells, that person is going to be entitled to a somewhat larger share of the proceeds of the sale of the house because they have been financially responsible for it after the date of separation. The same would be true if the person remained in the house and had to make major repairs, that kind of thing, if they're paying the property taxes. If the two people divorce and continue to equally share the costs of the house, then they're going to share the proceeds of the sale of the house pretty close to equally. One thing I would add to that, and this applies to almost anything that we're going to talk about when it comes to family law, especially money and property, is that where people want to be absolutely sure that they can have the outcome they want, they can write a domestic contract. And we're going to spend a whole hour next week talking about domestic contracts. It's one way to set out formally and legally how you want to resolve your differences should that day come. Okay, back to you, Sabrine.
Okay, thank you, Pam. The second question is, when can spouses make a domestic contract? Is it when they are getting married or anytime during the marriage?
Anytime. If you are already married and you're listening to this webinar today and you're thinking, gosh, I need it, I need a marriage contract, you can just go right on home after this is over and suggest to your spouse that you would like to have some conversations about a domestic contract. And then in that you set out the terms, when does it become binding? When is its effective date, and so on. In an ideal world, in my ideal world, everybody who moves into a common law or married relationship would write a domestic contract at the beginning of that relationship, but nobody wants to write them then because they love the other person. They are not wanting to think about the possibility that their relationship might end, and they certainly aren't able to consider the possibility that their partner might treat them badly. So my ideal world is probably never going to come to pass, but I think it's a lot tidier if it were just something we did, the way we go to the dentist or we go to the doctor. Oh, you're going to live with someone, have a domestic contract with them.
Thank you, Pam. The next question is the marriage contract on the website? So I could answer that. It is on the website. I sent the link in the chat box, and I will also email it to all the participants for their reference. The question after that is there a cost to CCMW consultation to draft a marriage contract? I'm going to assume that they did not know that we have a marriage contract. So if you'd like to elaborate on that question, please go ahead in the chat box. The question following that is, yes, go ahead.
Sabrine.
Yeah.
Sounds like Nizat wants to say something.
Yeah, I want to say something about the marriage contract toolkit. So it's actually a toolkit which includes a sample marriage contract. It's not the end all or be all. It's designed for you to use as you will. You can add to it, you can remove things from it. A very important resource in that toolkit is a supporting guide that helps make comparisons between Canadian and Muslim family law and guides people in the use of that sample marriage contract. We do not provide direct consultations on that contract. It's best that you contact a family lawyer when you're drafting a domestic contract, like the sample marriage contract that we have on our website. I think that's all I'll say about that, but do have a look. It's very interesting and very informative and is meant to be a sample or a guide rather than, a definitive document.
Thank you, Nezhat. The next question is, do these principles apply to properties in the homelands outside of Canada?
Again, if you're talking about Canadian family law, the answer to that is sometimes. I always hate being a lawyer when I have to say sometimes or it depends, but unfortunately that's our most common answer to most questions. If somebody is in that situation, it's really important that they meet with a lawyer and have discussions about, the nature of the property in wherever it is outside Canada, whose name is on the deed or on the registration of that property and so on. So it's not really a question I can answer in any detail here other than to say sometimes, and it definitely is worth investigating.
Thank you. The next question is, I was told if the property was bought before marriage, then the husband would have to pay off the mortgage, etc., and share the balance 50-50 with his wife. Is that correct?
Again, I'm assuming this is a question about under Canadian law, so please correct me if I'm wrong. And the question's just a little bit ambiguous. If the husband owns a house and still has a mortgage on it, and then marries in a Canadian civil marriage, then regardless of whether he pays off the mortgage or not, that house is the value of that house is to be shared jointly between the two people. So the husband owns the house, let's say it's worth $200,000, and there's a $100,000 mortgage on it. He gets married, the wife moves into the house, they live in it together for 20 years, 10 years, it doesn't matter. Over that period of time, either the husband alone could pay off the mortgage, or they could both pay off the mortgage. That would depend on the terms of their arrangement between them. Is one of them working outside the home and the other not? In any event, let's assume that by the time they separate, the mortgage has been paid off and the house is now worth $350,000. So that $350,000 has to be shared equally between the two people, even though the husband is the one who put down the down payment and had paid a good chunk of the mortgage before they got married. All of the other property that they have between them, a pension, the furniture in the house, RRSPs, investments of other kinds, and so on, the value that has to be shared equally between them is the value that increased between the date of marriage and the date they separated. Is that clear? I'm happy to try to be more specific, if that would help.
Thank you, Pam. I think if anybody wanted more elaboration, they can go ahead and ask in the chat box. I am going to go ahead to the next question. Can couples agree to treat the matrimonial home differently such that it would not be based on equalized division of that particular asset? If so, how can that be arranged based on Canadian laws?
Absolutely, through a domestic contract. So if I own the matrimonial home, hopefully my soon-to-be spouse will say yes, because if they say no, then who knows, maybe no wedding is going to happen. We're going to talk more about domestic contracts next week, so I think I'll save the long answer for that webinar, just to encourage you to come back and join us again. But the short answer is yes, you can opt yourself out of Canadian law by writing a valid domestic contract.
Thank you, Pam. The next question is, if one of the spouses has property before marriage, how would it be shared after in times of divorce?
Normally, property from before marriage stays the property of the person who had it before the marriage. If I have a very valuable painting before we get married, then that's my painting. A lot of this depends on a whole lot of other factors, but it is possible that I might have to share with my spouse the amount that the value of that painting increased during the years of marriage. So let's say I have a Picasso, it's worth $5 million. And at the time that we separate, it's worth $5.5 million. I may have to share that $500,000 with my spouse, but even that's not 100% certain. It's generally the value of property that accumulates between the date of marriage and the date of separation. My pension is worth $75,000 on the date of marriage. It's worth $300,000 on the date of separation. I have to share with my spouse the amount that accumulated. So 300,000 minus 75,000. I have to share the value of 225,000 with my spouse.
Thank you.
The way around this every time is to write a domestic contract saying either you're going to share everything 50-50, or this Picasso is mine and mine alone, and I don't even have to share the increase in the value that accumulated during the time we were married.
Thank you, Pam. The next question, Nazhat and Omar, feel free to step in as well. This question reads, can a husband sponsor his second wife abroad and bring her to Canada? There are some examples in the Muslim community in Canada.
Do you want me just to say what Canadian law would say about that? And then I'll be quiet. They would have to bring that second wife in claiming that she is something other than a second wife, because the second wife isn't a legal arrangement in Canada. So if I want to bring in my second wife, I'm going to have to sponsor her to come in as a as a caregiver or something else to bring her into Canada, because if I bring her in as my second wife, that's not going to be recognized. But I think perhaps Omar and Nizet could have some other comments to make about that.
This is a. I'm just going to quickly say this is a Canadian law question from the Muslim law perspective. This is a fairly straightforward. Classical schools agree that it's possible to have more than one wife, and if you're living away from home, you can have spouses, in a polygamous marriage, living together. So I think this is entirely a Canadian law issue.
I agree. It is a Canadian law issue because, as Pam said, the man cannot bring a second wife, someone whom he married overseas, as a wife, because that would be considered illegal in Canada. So, as Pam said, there might be alternatives, caregiver or some such thing, but
those are that's basically lying. But I just need to be clear about that, right?
exactly,
That's basically telling a lie on your immigration documents.
That's right. And I think because it's a lie, it's fraught with danger for both the wife and the husband.
Absolutely. And there are criminal charges that can follow just for that itself.
Correct. No more comment.
Thank you. The next question is rather lengthy, but I'm going to give it a shot. And it reads, I have seen women who are earning money from their job. They deposit their checks in the bank account and they give that full amount in the form of cash to their husband. When she gets a divorce, she has no money of her own and she didn't save anything. How will she ever get that money, especially when they were living in a rented place, which means no division of property either? The husband saves part of his money for his pay after paying the rent and bills and takes away her money too. Will she ever get her money back as there is no proof? Does the law do anything in this situation? The husband sends the money abroad so that he has nothing here to give her. I always wonder what she gets from the husband other than child support. And mediation doesn't work in this situation as the husband is stubborn.
Under the law, there's nothing she can do about that. As we talked about in the earlier part of the webinar, Canadian family law doesn't govern how people deal with their money while they're still together. They can do whatever they want. Now, the way I hear that story is that it's certainly a relationship where the husband has more power than the wife. I would even suggest that perhaps there's abuse in that relationship. So I'm not suggesting that the woman is willingly turning all this money over, but unfortunately, the Canadian family law just doesn't delve into that. If she's able to make a claim to the court for spousal support, if the husband earns more money than she does, then she might be able to receive ongoing money in that context. But she's not going to get the money back that she gave to him, because that's just going to be seen as the arrangement that the two of them had while they were married. And the court really isn't going to delve into that.
Thank you. The next question is, for how long does the spouse get the support from the government or from the other spouse who is earning more and giving the divorce? Is there a time period?
It depends on the nature of the marriage. And now here I'm simply talking about spousal support. I'm not sure what the reference to support from the government means, so I'm not addressing that right now. If these people were married for a long time and the wife stayed at home, or let's say she didn't stay at home, but the husband's job required them to move frequently, and so she kept changing jobs, and so never really moved beyond an entry-level position in any of her jobs. She could well be receiving spousal support for many, many years, possibly the rest of her life. If she remarries, it's quite likely the spousal support would end then. If she's younger and is able to get back into the workforce and become self-sufficient, then her support would diminish and eventually end. So there isn't a set number of years that spousal support runs for. It depends on the facts of the family situation.
Thank you, Pam. We have about 4 questions left. So this question reads, if the wife is staying in Canada, but the husband is in another country, how will the wife's property be distributed upon her death if she has no children?
Well, we're going to talk about that in our upcoming webinar on inheritance, and I would just as soon leave that question until then. I believe that's the final webinar in this series.
Okay, so the next question says, what about jewelry? How is jewelry divided?
I'm going to give one answer to that, but I also know that jewelry is often part of a mahar or a marriage contract, so I would welcome input from Omar or others from that perspective. My answer simply speaks to the basics of Canadian law. If it's property that was accumulated during the years of marriage, then the value of that property is shared. If the wife can prove that it was a gift from the husband, she may be able to succeed in having it not considered part of the net family property, which I described a little bit earlier. And likewise, if it's come into the family from outside, it may be excluded, or part of its value may be excluded from the calculation of net family property. But I know that jewelry can play a really big role in marriage, in the Muslim marriage contract or in the mahar. So Omar or anybody else, would you like to add to what I've said?
Yeah, I mean, as long as it's considered a gift to the wife, then it's her property. And here the principle, the general principle of the division of property applies. From what I've seen, usually jewelry is treated as something in addition to the mahr. So in that sense, it's the mahr has its own regime. Part of it is paid at the time of marriage and part of it later, and then any gifts which typically include the jewelry are the wife's property. There is no kind of confusion about it.
Okay, so there was a follow-up to that question saying if the jewelry was not a part of any marriage contract, does the answer stay the same, Pam?
Yes, I mean, my answer was pretty vague because it's looked at in the totality of everything else that's gone on in that relationship. But yeah, that my general and vague answer stands.
Okay, perfect. And the follow-up,
well, it's not perfect, but it's the best we can do.
The follow-up to the follow-up reads, how can she prove that it was a gift?
Well, that's a great question. And, often in relationships, somebody just brings a little gift home for the other person, but doesn't, so there's not a big production about it. I suppose if somebody was planning for the worst possible outcome in their relationship, they could ask their spouse to give them a card that says, this is a gift on our 25th anniversary, or this is a gift from my travels in Asia over the past 6 months, or whatever it might be. Certainly, if a gift comes with a card, happy birthday, honey, I know this will look beautiful around your neck, it's worth keeping that card. And I know, some of us are sentimental and nostalgic, and we keep every card we've ever been given. And other people look at the card for a few days and throw it out. But I certainly think it wouldn't be a bad idea to keep that card. Even if the card didn't say, I know this gift will look beautiful around your neck, you could print on the card on the day you get it, this card came with a gift of whatever, a pearl necklace or something like that. Essentially, though, in family court, when issues are being discussed and when there's disagreement between people, the court, if that's where things end up, or the mediator, if the mediator is trying to assist the people come to an agreement, is going to look at whose story is more believable. It's not a question of having to have, a photograph of the person handing you the necklace and saying, here's a gift to you and it's all yours. if the woman has a believable story about how that jewelry was given to her. Every year on her birthday, she got another jewel to add to a necklace or a bracelet, and the husband doesn't have an equally believable story that tells a different history, then she's probably going to be believed.
Thank you kindly, Pam.
But I think there's also a written comment here that I think is really helpful, and that is, in the case of jewelry given before marriage by a bride's parents, it's a good idea to get that in writing from the parents with a statement that that jewelry is hers and is to be excluded from the net family property. So that's a very helpful addition to this conversation.
Thank you. And Najia. The second last question reads, and again, I prompt Nazhat and Omar to step in if they like, as polygamy is very clearly illegal in Canada. But the question reads, if a second wife is a Canadian citizen and she wants to bring her husband who has a first wife back home, can she bring her husband?
I don't think I understand the question.
Okay, so it's Nuzet here. So essentially, the question is, let's say there's a woman here who knows that her husband, I assume that she knows that her husband has a first wife already in another country. Can she sponsor her husband? She's a second wife, knowing that there's a first wife already. Can she sponsor that man who is now her husband here? So I think that's what I'm hearing.
Well, I think that's tricky, don't you, Nuzat? Because once again, if she's claiming him as her husband, she's claiming him as her husband within a polygamous marriage, which isn't recognized under Canadian law.
I think that's how I'm understanding it, that it would still be illegal, knowing that, she's the second wife. So the spouse that she's hoping to sponsor already has a first wife. So it becomes a bigamous or polygamous marriage. So I think again it's fraught with peril, just because engaging in a polygamous relationship is a criminal act. So I think it's I think it's a problem. But I don't know how often this has happened, but it would be an interesting legal precedent to study if someone attempts to do that. Maybe some of the folks that are immigration lawyers in our communities may have a really good example of what occurs in this situation. But from a CCMW perspective, polygamy is against the law. So if you knowingly engage in it, you know that your husband has another wife already, and you're helping him actually by bringing him here. What is there to say that he may or may not sponsor the first wife? I mean, it's got so many questions and so many issues that one would have to deal with. It's a complicated issue, but in very simple terms, I think it would probably still be considered a criminal offense, knowing that she's a second wife.
And it's interesting to think about, because let's suppose just for an instant that she is successful in sponsoring her husband to come to Canada. He could then quite legally sponsor his first wife, because she would be seen under Canadian law as the wife. So, I mean, it gets very complicated and messy very quickly.
That's right. It would be very messy.
Great. I'm going to jump in and just ask the very last question, and then we'll go into the conclusion. So the last question is a prenup the same as a domestic contract?
Yes, it is a kind of domestic contract. It's a sort of old-fashioned phrase that we don't really use in Canada. I think it's used more in the United States. It would be the equivalent of a marriage contract.
Okay, great. So that is the end of the questions. we can now go to the evaluation slide. So thank you all for taking the time today to participate in this webinar. A special thank you to Pamela, Omar, and Nuzhat for facilitating and moderating this webinar. I will be sending each of you an evaluation by email. If you do not receive it by 5 p.m. this evening, please just let me know and I'll make sure to resend it to you. And I could also send everybody a link to our marriage contract toolkit that Nuzhat spoke about in greater detail. And if you have any questions, feel free to let us know at projects@ccmw.com. So we have some upcoming webinars left. We have about 3 webinars coming up now. We're looking forward to them. So again, they are taking place every Tuesday, beginning at 1 p.m. Eastern Standard Time. And we'll be sending those emails and reminders for those who would like to register, and we'll be sending them through our website, through our mailing list, and on our social media. So if you'd like to be connected to our mailing list, please just shoot one of us an email and we will definitely add you to it immediately. Thank you all, and we hope to see you all next Tuesday.
Thanks, everybody.
Until next week. Bye for now.
Bye-bye.
Bye.
Thank you. Bye.
Thank you.